Hey guys, so in this video, we'll be under the subject property and we'll be discussing immovable versus movable property. So these are under Articles 415 to 418 of the New Civil Code of the Philippines. So first we discuss what is immovable property. So under the Roman concept, it is that which cannot be transferred from one place to another because it is impossible to do so, or it cannot be transferred without suffering injury or destruction. So paragraph 1 is land by its very nature is immovable. Permanent structures adhering to the land, whether in owned land or rented land. Constructions adhere to the soil, like fence made of adobe stones, cemented dike buildings, which are permanent structures adhered to the land, are immovable, whether built in one's own land or rented, provided that they are more of a permanent structure and not mere superimpositions on the land like barong-barongs, mga barong-barongs. So a dismantled house or that na yung may mga materials na yung house would cease to be immovable, yung madali siyang masira, yung mga bahay na yero, shall legally be considered as personal property. So can a house be subject of chattel mortgage? So the answer is yes, provided the following are present. First, the parties mutually agreed to consider the house a personality. Second is that no innocent third party be prejudiced. So a building is a real property, thus its sale, as annotated in the chattel mortgage registry, cannot be given the legal effect of registration in the registry of real property. A building subjected to a chattel mortgage cannot be sold extrajudicially. So we go to paragraph 2, yung mga puno, yung mga plants. So trees by their very nature are immovable and cannot be moved from one place to another. So, pero pag pinuto sila or in-uproot sila, it becomes personal property because it ceased to be adhered to the soil. No matter what their size may be, trees and plants are considered real property by nature if they are spontaneous products of the soil, and by incorporation if they have been planted through labor. Plants adhered to the soil by incorporation are immovable, but if on pots used for ornamentation, it is personal property. Trees and plants planted on land are owned by registered owners of the land unless the owner has recognized the ownership in the hands of another. Yung standing crops naman, yung mga growing crops, they are real property by incorporation as long as they had not been gathered yet. If na-harvest na sila, then it is personal property, except in the case of uprooted timber. If the land is a timberland, this is because timber is an integral part of the timberland. So yung general rule is growing fruits are real property if naka-attach pa siya sa soil. Yung exception dito is if it is for the purposes of sale, for attachment and execution, and for applying chattel mortgage law. So we go now to the third paragraph. We see here everything attached to an immovable in a fixed manner in such a way that it cannot be separated therefrom without breaking the material or the duration of the object. So ito yung pag sineparate mo yung immovable, they regain their condition as movable. So for example, yung ceiling fan attached to a ceiling. Pero ano ba yung mga structures na pwedeng masira pag tinanggal mo sila? Kasi kumari, yung mga gate na masisira pag tinanggal mo sila sa pagiging gate. Yon. So the fact that the machineries were bolted or cemented or real property mortgage does not make them ipso facto immovable under Article 415, paragraph 3 and 5. As the party's intent has to be looked into, kailangan mong malaman kung ano din yung intent ng parties. Even if the properties appear to be immovable by nature, nothing prohibits the parties from treating them as chattels to secure an obligation under the principle of estoppel. So the breakage or injury in case of separation must be substantial. Hindi pwedeng sinira lang siya. So kailangan talaga na the thing or the property by itself breaks pag tinanggal mo siya and it ceases to be immovable property. So fourth paragraph naman, things placed on land or building with intention to attach them, immovables by incorporation and destination. The one who placed the statue or the statue rather, yung mga statues, must be the owner of the land or building or his representative or agents. So kung wari, yung mga fountain na makita natin sa malalaking houses, ganyan. So what are the requisites under this paragraph? So first is the place by the owner or by the tenant as agent of the owner. Second, with the intention of attaching them permanently. even if adherence will not involve breakage or injury. So we go now to paragraph 5. So, intended by the owner of the tenement for an industry or works being carried in the land or in a building and which are necessary for the pursuit of said industry or works. So, if the objects are separated, they become personal property. If machinery are installed by the lessee, the general rule is that these are personal or movable property. So, yung exception daw dito is the lessee agreed to give the machinery to the lessor upon termination of lease. Excuse me. So, under paragraph 5, what are the requisites to be considered na real property siya? First, it is that the machinery and the other things must be placed by the owner of the tenement or his agent. Second, the industry or works must be carried on in a building or piece of land. Third, the machinery and other things must stand directly to meet the needs of the said industry or works. And fourth, they must be essential and principal elements of an industry or works without which such industry cannot function or carry on the industrial purpose for which it was established. So dito, yung movables which are incidental cannot be considered immobilized. So kung wari, yung mga cash registers, typewriters, which are usually found sa mga hotels, sa mga restaurants, are merely incidentals, not considered immobilized by destination. For these businesses can continue or carry on their functions without these equipments. So we go now to paragraph 6. So animal houses, pigeon houses, beehives, fish ponds, or breeding places of similar nature in case their owner has placed them or preserves them with the intention to have them permanently attached to the land and forming a permanent part of it. The animals in these places are included. Animal houses adhere to the soil if purposely built to attach to the ground, the tree, the wall. Owner of the land intended it to be permanent. So the animal in the houses are considered part of the immovable. But if the animals escape, they cease to be part of the immovable. So what are the requisites under this paragraph? First is that the place by the owner or by the tenant as the agent of the owner with intention of permanent attachment. Second, forms permanent part of the immovable. So it may be considered as real property under Article 415 if its construction is adhered to the soil in a permanent manner, even if not placed by the owner of the immovable. So animals and pigeon houses, beehives, etc., are considered real property. So how about paragraph 7? So fertilizers, when they are used on land. So these are immovable by destination. Fertilizers are immovable if they are actually used because it is only when there can be no question that they form part of the land. So pag nasa bags pa daw yung fertilizers, personal property pa siya. Pero once na nilagay mo na siya sa lupa, nagiging na siyang real property. So even fertilizers already on the land for cultivation of which they are intended, but still in their containers, should still be regarded as movable property. Yun nga, sabi ko, pag nasa container pa sila, pero nandun na sila sinan, pwede pa rin silang mamove. So, movable property pa rin yun. So, paragraph 8, minerals found in these mines, when still attached, are real property. After extraction, it becomes chattels. So, they are considered immovable property, while the matter thereof forms part of the bed. That is, the matter thereof remains unsevered from the soil. Once severed, they become movable, for then they are no longer mines, but minerals. So pag naging minerals na sila, naging movable property nila. So what do we say about waters? So waters which are immovable, such as the sea, river, or lake, must not be confused with water itself, which is plainly movable property. So waters, either running or stagnant, are classified as immovables in most jurisdictions. So yung mga kanal, should be also considered as immovables. Water quarries, so they are lands where stones are chipped off or where sand is being extracted. Stones and sand are real property. Once extracted, they become immovables. Ano naman yung mga slag dumps? So they are waste and dirt taken from a mine and mounted on the surface of the ground under excavation. So we go now to paragraph 9. So yung mga docks, mga structures which though floating are intended by their nature and object to remain at a fixed place on a river, lake, or coast. So ito na nga, although floating, they are intended to be stationary. So considered as immovables though floating, as long as they are intended by their nature and object to remain at a fixed place on a river, a lake, or a coast. Since waters na either running or stagnant are considered immovables, it is logical that constructions that are united to them in a fixed and permanent manner, such as docks or structures, are also immovables. How about the vessels? So, yung vessels are considered personal property under the civil law and common law and occasionally referred to as a peculiar kind of personal property. It is essential that a record of documents affecting the title to a vessel be entered in the record of collector of customs at the port of entry. For example, a floating restaurant, ano ba, considered ba siya movable or immovable? So, yung answer dito is it depends. So, if the floating restaurant is in a fixed place, talagang nandun lang siya, na parang permanently na nandun lang siya, they are immovable. Parang, saan ba to? Sa Harbor View may ganyan eh. Pero, kung yung floating restaurant naman, meron din ito sa Manila Bay, yung parang nagpo-cruise siya, so magiging removable pa rin siya. So the only difference between a chattel mortgage of a vessel and chattel mortgage of a personality is that it is now necessary for a chattel mortgage of a vessel to be noted in the registry of the Register of Deeds, but it is essential that a record of documents affecting the title to a vessel be entered in the record of the collector of customs at the port of entry. Otherwise, a mortgage on a vessel is generally like other chattel mortgages as to its requisites and validity. So paragraph 10, lastly, sa immovable property. So the words contracts for public works are used in lieu of administrative concessions for public works. Dito daw sa Old Civil Code kasi they fit better with the present government and governmental practice. So ano nga ba to? General rule here is a personal right is always regarded as personal property. In the cases of public works which are considered as real property, a person's one-half interest in businesses is a personal property. So paano, to further explain this, where the rest of a right, so yung interest, is real property, the right itself is real property. Where it is when it is personal property, the right itself is personal property. Hence, ownership is real property if the thing owned is immovable and personal property if movable. Ganun daw yun. But a real estate mortgage which is not registered in the registry of property cannot be classified as immovable property, although it is valid as between the contracting parties. A personal right is always regarded personal property. The exception is in this case of contract for public works, which are considered as real property. So we go now to Article 416. So what are movable properties? What are the tests to determine whether a property is movable property? So first we have by exclusion, or those which are not included in Article 415. And the law has provided that a certain real property be treated as personal property. So punta muna tayo dun sa number 1, property not included in Article 415. So ano ba examples dito? Mga ships, mga vessels. So irrespective of size, one-half interest in a business, kumari, drugstore, being capable of appropriation and not included in the enumeration of real properties in Article 415, and may thus be the subject of chattel mortgage. Semi-movable such as wild or domesticated animals, except those mentioned in Article 415, paragraph 6, automobiles, books, money, jewelry, etc. So ito daw yung mga example nitong paragraph 1. How about paragraph 2? Real property considered personal property by special provision of the law. So yung mga growing crops are considered immovable under Article 415 as we discussed a while ago. But they are recognized as personal property by the chattel mortgage law and thus may be object of the chattel mortgage. So in a case, the first question raised was whether the sugarcane in question was personal or real property sa isang case to. If personal, it could not be the subject of legal redemption sought to be enforced. So citing a decision of the Supreme Court of Louisiana, our Supreme Court ruled that growing crops or ungathered products raised by labor and cultivation are considered personal property. So the existence of a right on growing crops is a mobilization by anticipation, gathering as it were in advance, rendering the crop movable. So paragraph 3 is forces of nature. Example, electricity, gas, rays, heat, light, oxygen, atomic energy, water power, etc. So on the question of whether electricity, parang naging ano rin to before naging famous question na yung electricity ba pag ginumber, is that considered theft or ano ba? Immovable ba siya? Movable property. So, on the question of whether electricity can be subject of theft, it was ruled that it is true that electricity is no longer as formally regarded by electricians as fluid, but its manifestations and effects, like those of gas, may be seen and felt. So, pwede na siyang subject of theft. The true test of what is a proper subject of theft seems to be not whether the subject is corporeal or incorporeal, but whether it is capable of appropriation by another than the owner. So electricity, the same as gas, is a valuable article of merchandise bought and sold like personal property and is capable of appropriation by another. So pwede siyang nakawin, gaya nga nung nangyayari ngayon sa mga jumper. While the fourth paragraph, in general, all movable things. So ano ba to? May three tests daw that may be applied to determine whether a particular object is movable property or not. So first is whether the property can be transported or carried from place to place. Second, whether such change of location can be made without injuring the immovable to which the object may be attached. And third, whether the object does not fall within any of the 10 cases enumerated in Article 415. So basta namumove mo siya, consider siya as movable property. So next we go to Article 417. So obligations and actions. These are personal, really personal rights. So they having a definite passive subject. The word property in law has acquired a meaning which goes beyond material objects and comprehends also rights. Material things are called corporeal property, as distinguished from the incorporeal property, which refer to rights. So our Article 417, paragraph 1, includes infinite variety of contracts, promises, or obligations which confer on one party the right to recover movable property or a sum of money from another by action. So a promissory note is personal property because it gives the creditor the right to collect his credit. But if a loan is secured by a real estate mortgage, the loan is real property by analogy as a real right over immovable property. Ano naman yung demandable sums? So this means that the amounts are liquidated or determined. So both the obligations and actions must be legally demandable and enforceable. Well, paragraph 2 is about shares of stocks. So they are personal property and therefore can be subject matter of a chattel mortgage. So are the certificate themselves evidencing the ownership of the shares? The term entities mentioned in Article 417, paragraph 2, should be deemed to include all juridical persons, even partnerships, although they do not issue shares of stocks. So the word stock means participation or interest. Thus, it has been held that a half interest in a drugstore, kumare, business, is personal property. But the interest in the business must not be confused with interest in the real property of a business entity, which interest is also real property. Then other incorporeal real property examples are intellectual property such as copyrights, patents, trademarks, rights to invention, etc. Intellectual creation is recognized in the Civil Code as a mode of acquiring ownership. So personal property rin to yung mga copyright natin sa mga articles, for example, ngayon sa mga videos. So these are also considered personal property. So let's go. Let's go now to Article 418. So movable property is either consumable or non-consumable. So Article 418 classifies movable property based upon its aptitude to repeated use into either consumable ba siya or non-consumable. The distinction serves a useful purpose. Thus, consumable goods, for example, yung food, money, cannot be subject matter of a contract of comodatum unless the purpose of the contract is not the consumption of the object as when it is merely for exhibition. So in simple loan or mutuum, the subject matter is money or other consumable thing. Generally, use of rock should not include things which are consumed when used. So another classification of movable property, according to the intention or purpose of the parties, is into fungible and non-fungible. So on the other hand, the consumability of the movable property depends upon the nature of the things itself. So a thing is fungible if it can be substituted by another thing of the same kind, quantity and quality, and not fungible if not replaceable in such equivalence. So thus, kumare, rice it is by its nature consumable. But if the parties intend a loan of rice for display or exhibition, parang it is in that sense na magiging non-fungible siya because the identical rice need to be returned. If the rice is loaned for consumption, it is not only consumable but also fungible. So money by its nature is non-consumable, but it is considered consumable in the sense that when used, yung money leaves the owner who thereby parts with it. Money is fungible because the debtor need only to return an equivalent amount in case of a simple loan. But if the obligation is that the identical bills given are the same ones to be returned, then the money is non-fungible. Pag sinabing talagang itong serial number ng pera na to, di ba? So the obligation to deliver 10 copies of a particular book involves fungible, non-consumable things. So the old civil code used the words fungible or non-fungible, but the new civil code changed them to consumable or non-consumable. So the terms consumable and fungible are used interchangeably in Article 1933, which provides that the subject matter of mutuum is money or other consumable thing. On the other hand, Article 1953, referring to the obligation of the debtor in mutuum, speaks of money or any other fungible things. So to recap, how do you classify object as to their consumability? Pag consumable property siya, it cannot be used in a manner appropriate to their nature without being consumed. Pag non-consumable property, one which can be used without it being consumed, being eaten, or used. So the test is whether a property can be used over and over again. If yes, if it is non-consumable. Okay, so that ends our short discussion for movable and immovable properties. I hope you learned something from my video today. Thank you for listening.